Good evening and welcome to Business Law KB3. From today onwards, I will be lecturing on company related legal matters, what we call company law. In this particular subject, I will be basically touching upon introduction to the subject, nature of corporate personality, that is also describing the natural person and a body corporate, similarities and differences between the personalities under discussion, corporate personality and the company law, and especially the Salmon versus Salmon and Company, which is considered one of the cornerstones of company law. And about the history of company law, the characteristics of a company, incorporation of a company, rights and liabilities of shareholders, and discussing mainly on the Ashbury Railway Carriage and Iron Company versus Reacher case, directors and their qualifications, disqualifications of directors. And thereupon, I will be touching the other contents relating to company law when we are dealing with those topics. First of all, I would like to introduce the subject by explaining the importance of commercial activities and the law. The commercial activities started not so far in this world, even though trading had been happening ever since the evolution of human beings. However, when it came to commercial activities, people wanted to have the legal enforcement to those commercial activities, especially to deal with the rights and duties of the parties involved in these commercial transactions. So for that, they simply wanted the law to apply and a law to be developed to apply with regard to commercial transactions. Therefore, in various areas, the commercial law was developed. For example, if you take a sale of goods, the law on sale of goods was created, as well as law of contracts applying to the contracts that have been made between the parties, and company law, which governs the corporate entities throughout this history ever since a corporate body was formed in this world. So likewise, many legal principles were developed, many rules and regulations came to being, applying to the commercial activities and commercial transactions that took place. So it was of utmost importance to regulate the commercial world, where people used to conduct their commercial activities. So regulating the commercial world was not an easy task. It was indeed a difficult role to play. We know that regulating means you bring the affairs of the commercial world to some sort of harmonization, unification within a country system and within the international system to bring these laws pertaining to commercial activities, including company law, under one umbrella, so that there won't be any conflicts between those who operate in different jurisdictions. This is very important, as we see now that there are many international, multinational companies operating in different parts of the world, such as, for example, a company like Coca-Cola that has the main head office in USA and spread to almost all the countries in the world with its corporate bodies functioning in those respective jurisdictions. So for that particular organization to survive in these different jurisdictions alongside its parent company in USA, the law need to regulate the existence and the coexistence of the main company as well as the other substituents in other countries, so as to create harmony in the operation and the conduct of their business activities. And this is why regulating the commercial world is extremely critical to anyone who is engaged in commercial activities, including that of companies. Then there have to be controls and statutory enforcements so that the commercial world would play somewhat compatible role due to the controls and statutory enforcement that are in place in any jurisdiction in the world. Domestically as well as internationally, these controls and statutory enforcement have been made possible due to the emergence and prevalence of the domestic law as well as the international law pertaining to commercial transactions and of other commercial activities. Then let's talk about how commercial relationships emerged. We know in the history there weren't that much of commercial activities that took place. They were mainly and basically of traditional means. The society was not that complicated. The society was quite basic and simple. So that systems like an exchange transaction, what we used to call barter system, and other types of transactions involve basic elements of commercial nature. But however, with more and more relationships taking place in the commercial field, especially where the relationships extended to a more commercial in nature rather than of a traditional method. The regulatory and legal framework for the domestic and international relationships in commercial area were of significant character. They required the controls and statutory enforcements, as I mentioned to you before. But most of all, they required all these transactions and other affairs to be regularized through rules and regulations, or what we call the law. Now, when it comes to domestic commercial activities, the domestic law can apply to those transactions without much of a hassle. It is the domestic law that applies to any transaction in commercial terms that operate within a particular jurisdiction or a land or a country. But however, when the business develop and they spread to other parts of the world, then obviously many conflicts come into play. Now, take for example a simple transaction between party A and party B on one land. If I may draw this, you would see that in a certain land, say land A, there is one man by the name P having a commercial transaction with another person called Q. For the commercial transaction that P and Q are entering into, it is this land A law related to commercial activities would apply. But however, when there is a business transaction between a person in land A called M and land B called N, then the transaction between them obviously require the application of some sort of a adaptable and compatible law to both these people, M and N, who are in two different lands or countries. If M wants to apply its land A's law on commercial activities to this transaction with N from land B, or vice versa, where N wants to apply its own land B law for commercial activities for the transaction with M of land A, conflict of laws tend to exist. In order to evade the conflict of laws and allow M and N to do their commercial transaction in a smooth manner, obviously they need a law that is compatible to both land A and land B, in which M and N respectively reside. So, therefore, the application of an international law is a must to the transaction of two different people in two different lands. That is why the international law was developed to accommodate people engaged in international trade to simply rely upon these international laws that could aptly adapt to the transaction that they are involved. So, unlike in the case of a domestic commercial affair, the international commercial affairs require a compatible international law to apply to their transaction in order to overcome conflict of law issues. Now, in this world, we see that there is a lot of international trade taking place. So, in order to allow international trade to take place, you need to provide international legal rules for such transactions. There are various organizations, especially from the United Nations, who are creating more adaptable international rules and regulations for the harmonization and unification of varying degrees of laws, enabling people from different countries who are involved in this international trade to be capable of applying these international laws into their system and into the transaction. Now, one may wonder whether harmonization would be just possible by creating international law. No, it is not. Once an international law is made, it should be brought into the domestic structure through certain acceptable means to those respective lands. For example, in the common law system or in the countries of the Commonwealth, there is what we call the dualistic approach, where the international law must come through their respective parliaments, local parliaments, and a local corresponding act need to be enacted, so that the local law along with the ratification instrument be deposited with the international organization in order to give effect to that international law to that particular state. In civil law countries, but they practice the monastic approach, where international law can be straight away adopted by the respective parliament of that state and give effect without having a national legislation. And that passing of the international law with the ratification would be sufficient to give force to that particular international law in that particular country. Once that is done, this international law will apply to land A and land B in this example, and there will be no conflict of laws between the transactions of M and N, and that would harmonize rather their undertakings and their transactions, so as to provide a level playing field for both parties. Then the most difficult issue that may arise would be with regard to dispute resolution. Whenever there is a dispute between the parties to a commercial transaction, especially in international trade where parties are in two different countries, the particular dispute has to be resolved in an agreed jurisdiction so that both parties to this transaction would be fairly and reasonably treated and justly treated, and they would not be treated arbitrarily or with bias to one party. In doing so, you need to have a proper dispute resolution system, both in domestic as well as in international levels. So, dispute resolution is a very important area in the commercial field. And when it comes to methods and means of resolving dispute, we know that the final place of adjudication is a court of law. Court of law have been always there as the main and the last resort for those who require the dispute resolution or resolving disputes when their rights and entitlements have been infringed. So, people in the commercial field especially didn't want to lose their money and time with lengthy court proceedings in particular, and thereby thought of resolving their disputes through much simplified manner with time saving, cost saving and many other concerns of financial and physical easiness. Methods such as arbitration, negotiation, reconciliation, mediation were developed in order to satisfy these ends and to accommodate the dispute resolution, especially in international setup, but not only international setup, also in the national setup, so that those who are in the business transactions could expeditiously and economically resolve their disputes at hand. Now, after that introduction to the main skeleton of our subject, I would like to now talk about the nature of personality involved in business transactions. Businesses are being conducted by various persons. Who is a person? A person can be like us, a biological character made up of blood and flesh. Also, there can be a person who could be a corporate entity that is legalized by the corporate law. A person can be a partnership. A person can be other. So, if you try to interpret who is a person, there will be different types of characters you may see in such a definition. As one of the simplest definitions that I could give you is that a person is a human being like us, biological person, or a creation by statute, a creation by the law. And these includes naturally being born and living, and juridical in nature. Juridical means that something that has created that person, like the law that has created that person. Extending also to different types of models such as associations, partnerships, companies, corporations, organizations, firms, legal representatives, states and counties. Now, the first question that may come up to your mind would be, what is the difference between a natural person and a juridical person who has been created by the law or a statute? A natural person by nature is a biological creation like us, a human being. A human being. While a juridical person is a creation of the law. It is the law that has created that man. It is the law that has created that person. A juridical person is not born. A juridical person is created by the law. The law that has the ability to create such a person. Now, first thing that in any juridical personality that is being formed, we may see the term association associated with that. Now, what is an association? Association, as we generally hear it, is a kind of organization, or some have associated to form something, but more legally speaking, it is any group of people who have joined together for a particular purpose, having commercial or non-commercial objectives, with a body legally established or not, in the nature of an organization, partnership or company. Now, if I may elaborate further, what is an association? It is any group of people. So, you need people's presence to form an association. Without the presence of people, an association cannot be formed. So, of utmost importance is the people, the natural human beings to form such a thing. But not everyone who come to form such association can be considered falling into this group, but only those who join together for a particular purpose. That is important. All these people have joined together to form this particular association for a particular purpose. Not that Mr. A has one purpose, Mr. B has another purpose, Mr. C has another purpose. It is where A, B, C has one common particular person in their mind and have discussed to form this association. And having commercial or non-commercial objectives. Having objectives of a commercial nature, that is to make money or make business, or non-commercial or not to make money, more of a charity, where we see sometimes associations being formed to do business or for charity. So, for any of these things, if this group of people have joined with a particular purpose for the objective of raising commercial or non-commercial, means with a body legally established or not, either the particular body has been legally established in writing, in a more formal, proper way of doing, or quite informally, that they have, like in this group, they have informally made up this association. Both things are possible, but in the nature of an organization, but however, they have formed it in the nature of an organization or as a partnership together or as a company. So, you could see that the company, which is the focal point in our business law lecture series today, is formed through some kind of association of the people. So, what makes us understand, first of all, is that a company is primarily an association. So, a company is primarily an association. An association that is being formed by people, human beings. So, a company derives mainly from natural people. That is the basic element of a company. How does any association or alliance is formed? Either by way of a statutory provision or by registration alone. That means that there may be a particular law that would apply for the creation of this association, such as an Act of Parliament. If you look at the Chartered Accountants, is an association formed under an Act of Parliament. There can be also associations being formed by registration alone, that is either by registering it in a certain place. Now, if you look at, for example, a trade union is an association that is registered under a particular trade organization or in the particular business place where the trade union exists, where the owners or the management of that business place recognize the existence of this trade union. So, in whatever way they may register, and alone consisting of a group of persons, or companies, or it may also be a collection of companies that form an association, having common objectives, most importantly having common objectives. Not that the different members of this group have different opinions and objectives, or not the opinions but the objectives. The objectives have to be common. As a means of original formation of this association, or in the course of a merging of several associations into one organization, either to form an association or merging of few associations together. Now, I told you that a company is being created first of all by the people, but however it is through the association of these people that the final product of company is being formed. So, a body corporate, which is a company is a body corporate, is basically being formed by an association. So, what is this body corporate? It is a body that is formed, constituted under the law relating to companies in that particular jurisdiction or the country. Now, according to Lord Lindley, a body corporate is an association of many persons who contribute monies worth to a common stock and employs it in some trade or business and share profit or loss arising therefrom. So, what Lord Lindley mentioned or declared his view for an association in a famous case in England, he expressed that an association or a body corporate is an association of many persons who contribute money, financial aspect, worth to a common stock worth to a common stock, where the money that different people contribute forms into a common stock, and it employs that particular stock in a particular trade, some trade or business, and whatever the profit or loss that arise out of this particular investment comes back for the benefit of those who have formed this association. So this is how the group of people in this association benefit out of a association that they make, and a body corporate would formalize the respective members of these groups, this group entitlement as to the profit or liabilities as to loss. And these types of body corporates may include public corporations or public corporates, private entities, public-private entities, onshore entities, offshore entities, etc., etc. In Sri Lanka, let me give you some examples for these different types of body corporates. In the public sector, we know we have corporations. Sometimes they are also called state-owned enterprises, SOE. Now, these corporations have been formed with government or the public money, naturally through the investment of the general treasury. So, these public corporations operate on business or service oriented matters or of objectives, and they've been benefited out of the public coffer or the government coffer. So that's why they are called public corporations. When it comes to private, we know that there are plethora of entities existing as private companies. Take for example, one of the leading organizations in this country, such as Haley's. It started as a private company, but with the enlargement of its business structure and wealth, it has gone into a status of publicly listed companies where general public could invest. Now let's take a form of a very simple company. Say company A, which is a very simple company, is of a very private in nature. So this particular private company is a company purely owned by private individuals, or where pure private individuals have invested into this company. There is no public money involved. These private companies will exist as private companies, and they may even grow to a stage such as the Haley's example that I took, in order to be listed in the stock market, so that the general public could subscribe shares, invest through the stock market in the shares of those publicly held companies. The third example that I have taken is a public-private initiative. Classic example is Sri Lanka Telecom. Sri Lanka Telecom was a government establishment, but later it was privatized in a way that the government still holds a certain percentage of shares, while rest of the shares are sold to the public, and people or companies can invest in buying those shares. So there is a public-private partnership in such a business. There are several other organizations in our country that have public-private partnerships. Another leading example that I can give you is the port of Hambantota, that is now being owned partly by the Chinese company and partly owned by the government of Sri Lanka. So this is a public-private partnership scenario. Then also there are companies that have their presence on land. We know that most of the companies are located on land. So when a company is located on land, we say it's an onshore company. But also there may be companies that are located either at sea or at another country. Both these scenarios are called offshore companies. Now take an oil platform, a company that produces oil from an oil well at sea can have its presence at sea. So it is an offshore company. But also on the other hand, offshore companies means that when a company's presence is not has also in another country apart from its main principal country, like the example of the Coca-Cola company that I took. The mother parent company is in USA and it may have offshore companies in Sri Lanka and in other countries. So the companies that are basically out of its mainland or its own country called offshore companies. So therefore, there are many body corporates in different types in the present commercial world. Now let us see the similarities and differences between these personalities that I was talking about. I explained who is a natural person, what is an association. So now let us discuss the similarities and differences between the natural persons and associations. A person being an individual of biological means with a given identity like us, human beings, is a natural person, in contrast to an association that is a collective initiative of a group of persons or of companies, or both in a mixture with a defined identity given by its registration or by statute. So therefore, even though natural persons are included in an association, whenever an association is created, association takes the form of its own. Now take for example, if a man called A enters into an association with B and C, in this particular association, these three people form the group. So the association would be different from A being alone, even though A is inside this association. So you could see that A as a natural person operates within the association, but he takes a different form when he is within the association. So that is the difference between a natural person and an association. And thereafter, let us see what are the similarities between association and partnership. An association of two or more people engaged in a social or business enterprise having a common objectives, holding co-ownership, especially in a business activity, with each partner holding responsibility and liability on joint and several basis. The difference between a corporate entity and a partnership is that a partnership is an association where the respective partners in that association have come for a common objective, but for the existence of the partnership, they appear to be different individuals rather than of one common entity. One common entity is a company, whereas a partnership exists with the people who are involved in this association. So it is a social or business enterprise having a common objective, where these people in that association or in the partnership rather holding co-ownership in that particular partnership or in the business activity, with each partner holding responsibility and liability, such as liability to pay tax, to be individually borne by the respective partners rather than of a collective nature, and they are jointly and severally liable in a way where whenever there is a liability upon the partnership, all the partners are expected to contribute jointly, and if one party evades such burden for the contribution or the obligation to the contribution, then the rest of the parties will have to bear the same liability that the evading party evades. Now, let us take an example to clarify this further. Let us say that there are partners A, B, C who have partnered and formed a partnership by the name of Albert and Sons. Albert and Sons. So, ABC is a partnership known as Albert and Sons. And just assume that Albert and Sons is involved in a business where whatever the business activities that they are doing, within this partnership, A is a co-owner, B is a co-owner, C is a co-owner. And the profit or the loss that Albert and Sons is making in the business is shared among A, B, C separately as to the agreed ratio what A, B and C have agreed at the time of the formation of the partnership agreement. And also at times of any liability of Albert and Sons to a third party, it is A, B, C who have to jointly contribute towards the loss incurred by the third party. And in such a case, it would also be in the same ratio that A, B, C have formed this partnership. And on top of that, if one party does not turn up to provide the liability here, such as where, for example, A is hiding, evading his liability, then B and C are liable to contribute together A's part as well. Now, that is what we call being jointly and severally liable. So, this is the way that partnerships operate. Within an association, whenever you make up a partnership, the partnership operates in such a way. Partnership is a creation of persons and hold individuals responsible, while a corporate is a creation by the law with individuals only holding the shares, where corporate holds distinct liability outside the shareholders. Now, this is the peculiar nature of a corporate entity. If you take the same example where A, B, C forms Albert and Sons Private Limited. This is a body corporate. That under the prevailing law applying to companies, A, B, C have come together as what we call the shareholders of Albert and Sons Private Limited. So, ABC have formed Albert and Sons Private Limited, a company, but the real difference here between that earlier partnership and this company is that this particular Albert and Sons Private Limited exists separately from its creators or the shareholders. This is a separate and distinct personality of its own, so that ABC being natural persons may be the creators who invested their money and took up the shares of this corporate body, company, but still this particular company that they created has its own existence outside the creators ABC. Albert and Sons Private Limited has its own existence as a distinct person from A, B and C. So, this is the nature of a company or a corporate body, and corporate body holds distinct liability outside the shareholders, where that particular corporate body by itself will be liable, and that liability cannot be passed on to the shareholders who are inside that particular corporate body. So, the liability rests upon the corporate body, and the corporate body takes up this liability without making the respective natural persons who are the shareholders being liable for any wrong that the company has done. But however, here provided I would say that there are certain exceptions, and those exceptions will be dealt later on in the subject, how such shareholders or the people who are inside the company, such as the directors, would become liable for any wrongdoing of the company. Now, in a corporate body, we see first of all the shareholders, and secondly the directors. Now, shareholders are those who create the company, those who invest in the company, those who provided the capital to the company, and they form the company. But however, in order to carry out the company activities, you need people of some ability, capability, of certain professional standard, competence, skills and so forth, to engage in day-to-day activities of that company. So, you need people to manage a company. These people who would manage the company, such as say person M, person N who would manage this particular company manage or administer the company's affairs are called the directors, while the creators are called shareholders. Those who run the day-to-day activities and manage the company are called the directors of the company. A corporate or a company is distinct from its shareholders, as you know, who are the creators, while the directors act as agents of the company for their role of conducting business activities on behalf of the company. Directors are appointed by the shareholders, but the director's duties lie upon the company to properly manage the affairs of the company, and they act as agents of the company, so appointed by the shareholders, and are liable only in event of their personal wrongdoing. For any activities that the company may become liable, that liability passes upon the directors only in circumstance where directors have done personal wrongdoing. Otherwise, they are protected, like the shareholders in the earlier scenario that I mentioned. So, the corporate liability would not extend either to shareholders or to directors, as long as the shareholders and or directors have not done anything wrong in their personal capacities with regard to the wrongdoing that the company itself has done. So, now let us look at what is a corporate personality and the company law. Now, this is a very significant feature where a company has a corporate personality outside those who have formed that particular company or those who are managing the company, such as the directors. Now, before we come into the substance of the question that I raised, let me clarify what is a company in law. A company is an association, as I mentioned before, or a collection of individuals, like I showed there, whether natural persons or legal persons involved in such thing, or a mixture of both. Now, a company may consist of natural persons such as A, B and C, and also it may have another company within a company, such as say company D, company E, for example. Now, if you look at this particular company, the owners, or what we call the shareholders in law of this particular company, are the natural persons A, B and C plus two other companies who have come into this particular company as shareholders, the company D and company E. So that's why it says that a company is an association or a collection of individuals, whether natural persons or legal persons, or a mixture of both. So it could be either company exists with purely natural people or purely corporate people, corporate personalities, or a mixture. It acquires the characteristic nature of being a legal person. It is not a natural person. Company is not a natural person, even though natural people might be inside, but it is a legal person created by the law itself. I mean, the law is the company law. Company law that has created this company. And it acquires the nature of being a legal person, having the right to sue. Now that is a very important element in a company, that this particular company has the right to sue another party in its own name. So we say that this particular company's name is ABC Company Limited. This ABC Company Limited can sue another party by its own name. So let's say ABC Company Limited is suing Peter. So ABC Company Limited can sue by its own name this Peter. So it need not that A, B, C company, D company, E together sue Peter. It is one, this entire personality sue Peter. ABC Company Limited sue Peter. This is a very important characteristic in company law, that a company being a legal person acquires the title to sue. Title to sue someone else. And also in return, it could also be sued by Peter. It can sue and be sued. Likewise, a natural human being. So it's called an artificial person. Therefore, a company is not a natural person as we see, as we know, but it is called an artificial person. It is a person created by the law. It's not a person created in biological means. The next question that I would like to raise is whether a company is same as its shareholders. Now I am sure that you would be able to give an answer, straightforward answer saying no. Perfectly yes. A company is different from its shareholders. A company is a distinct person operating separately from its shareholders, though it has no existence without the shareholders themselves, because you need the natural persons to drive the company's existence. Without natural persons, the company does not exist. Now, if you look at this scenario, if A, B, C are not there, and also company D's shareholders are not there, company E's shareholders are not there, this company is completely a vacuum, cannot exist. So you need natural people to lead a company. So therefore, it cannot exist without the shareholders, though a company has its own legal personality, separate and distinct from the shareholders, but remains as a distinct person in law, having the power to represent itself before the law. As I mentioned, the right to sue and the obligation to be sued. Can a company sue and be sued in its name? Of course, yes. As long as, like I mentioned, that the company has its own name, the company can sue in its own name, and company can be sued in its own name. Being a legally recognized person before the law, it can sue and be sued in its own name, irrespective of being represented by its shareholders or directors. The incorporation under the law of the state in which it is registered enables it to be identified as a person who is legally created and termed as a juridical person. So therefore, a company being a juridical person has the title to sue and be sued, and it can sue and be sued in its own name. Now today, I would like to end this lecture at this point, as now we have grasped a basic knowledge on how a company exists in the commercial world and how a company could be termed outside the existence of its real shareholders. Let's meet up tomorrow at the same time with my next presentation on business law. Thank you very much.